matter will now be thrown open for panel discussion, which I hope will be stimulated by questions from the floor as much as possible. So I'll throw the matter, seminar open for the panel discussion. Are there any questions from the floor, or would you rather the panel initiate the discussion for themselves? Do we have any questions first? Well, just to set the ball rolling.
Sorry, Don, if I could just interrupt, you grab the microphone.
If I could set the ball rolling, you'll recall that Stephen touched on the style to be adopted in the preparation of appeal statements where the appeal is brought in the federal court, and he suggested that the statement should be drawn like a pleading, but and should be succinct but persuasive. So I'll ask the other panellists to comment on that view.
Thank you, Don. I think the important thing to reflect upon with appeal statements is that they are like a pleading, in a sense, defining the ambit of your case. So if you do not give sufficient care to the appeal statement, then you could be faced with problems, one of which is that come the scheduling conference, you will have heard that Stephen mentioned that now requests for particulars are not entertained. The expectation is that any request for particulars will have been dealt with at the scheduling conference. And some judges expect quite a lot of practitioners at the scheduling conference, so that if they do not understand your appeal statement, you can expect a number of possibly embarrassing questions. And likewise, the expectation is in your appeal statement that you will have surveyed the relevant evidence which goes to ground the claims that you are making. So, as Stephen said, the appeal statement has some similarities to a pleading. I don't know that there's much merit in discussing the comparisons between a pleading and an appeal statement. I've certainly had appeal statements come my way which specifically refer to particulars of various claims, and it's certainly a very good starting point to approach the appeal statement on the basis that it must set out the material facts. But in addition, as the practice note requires, the appeal statement must also set out the parties' contentions and the principal authorities which support those contentions. So it is an area which requires a lot of input from the lawyers at the time of commencement, and this is where counsel's involvement may be of assistance, because it is all too easy, as I suspect a number of us have had experience, to go down the merry track towards trial, thinking that one has the evidence required to ground a particular factual or legal assertion, only to discover that the evidence upon which you are relying is objectionable evidence. It's inadmissible because it's opinion evidence, or it's simply irrelevant, or it is hearsay evidence. And this is where having another set of eyes from counsel look over an appeal statement, or ideally draft the appeal statement, can set you on the right foot. It is also the time to consider whether you need to be issuing subpoenas. You can fast track the issue of subpoenas by discussing them with the judge who appears at the scheduling conference. In the past few years, that has often been Justice Gordon, and she is certainly one who does expect the parties to essentially know their case. So if you have a case which is going to require expert evidence, she's going to expect you to explain why you need that expert evidence, and hence you will have essentially had to do the hard work in advance to analyse your case, the elements of the case, and work out at that early stage what are the likely issues. Another factor to be borne in mind is to what extent can some of the issues be dealt with by way of an agreed statement of facts. I had a case, it was Norman Layton and the Commissioner of Taxation, which is reported, well, the full court decision is reported at 2011 FCAFC 96, where the entire case proceeded by way of an agreed statement of facts, notwithstanding that the parties initially filed evidence, including expert evidence. But also keep in mind that an agreed statement of facts can be a double-edged sword, because once you have an agreed statement of facts, you will need leave under the Evidence Act, I think it's Section 191, before you are allowed to add to or qualify any statement of agreed fact between the parties. So it's not something to give to, say, a junior lawyer who does not fully comprehend the case. It is an agreed statement of facts is essentially binding you to the facts in question. You will need to seek leave if you wish to depart from them. And likewise, as the tax practice note says, at the scheduling conference, each party will be required to bring along an initial list of witnesses and a brief summary of each witness's expected evidence, and the judge is likely to request you to explain the relevance of that evidence unless it is obvious. So a lot of thought needs to be given. Tax cases now are a lot more front-ended than they used to be. There is a lot more hands-on approach on the part of the judges towards them, and it saves time and it saves money for all concerned if that effort is put into them at the early stage. So I might now hand over to Michael, who may have some comments.
Look, I agree with everything that the two messages come out. First of all, the appeal statement at the early stage is interlinked with the evidence that's going to be at the case for a taxpayer. It's less of an issue for the Commissioner, who's got more resources and presumably has an opinion about it much earlier. The biggest issue that I find arising with appeal statements in the initial scheduling conference is where you have a smaller firm, usually from accountants or a suburban firm, who's lodged the application to the federal court without due thought. A brief comes to council 2 weeks before the appeal statement, the scheduling conference is due, and it's the first time anybody's considered it. My practice in those circumstances is to beg, borrow and steal an extension of time rather than try and comply. The court is understanding that does happen from time to time. But if you're acting for a larger firm who has more resources for taxpayers, which is where most of my experience is in, you will get less sympathy, and it will be an unpleasant experience. There is one exception I have to what Ian said about details in appeal statements, and that is where there's risks of criminal prosecution for a taxpayer. Those sorts of cases need to be handled exceptionally carefully, because the appeal statement, like any other pleading, is given on instructions, and the content of it is something that a taxpayer who's being prosecuted could be cross-examined about in a criminal prosecution by way of admission. So subject to that exception, I think I endorse the concept that everything should be as detailed as possible, without losing sight of the fact the document has to be helpful. Anything else?
I was actually just going to make the observation that I've noticed a bit of a shift in the way that appeal statements look. When they first came in and the tax list practice note first came in, everyone was like, oh, it has to have authorities in it. And you get these incredibly detailed, almost submission-like contentions, whereas in the past couple of years, I've noticed the trend seems to be to retract from that. Quite often, I'm now seeing appeal statements settled by eminent senior counsel that don't refer to authorities at all, notwithstanding that's what the practice note actually ostensibly requires. So it does seem, in in my view, that we're sort of shifting back to where we were during the statement of facts, issues and contentions days, and I'm happy to have someone disagree with me. The other thing that I've noticed is that it seems to be relaxing a bit more with the scheduling conference, as in I haven't been to one for the last 12 months, almost invariably being dealt with on the papers these days in my experience, whereas in the early days of the practice note, that would have just been unheard of. You would have expected a full complement of counsel available at the scheduling conference, but it seems to be a little bit more relaxed.
Well, my experience has been exactly to the contrary, so I suppose it depends on who the judges are, who the counsels are, and the nature of the issues. Can I just comment on agreed statements of facts as well? I think I've done 2 or 3 cases. There's certainly Watson, Federal Commission Taxation. Greenhatch is another one that was run on agreed statements of facts very effectively. I think Melanie was involved in Greenhatch. We left, yeah. We got the calculations wrong, but nothing turned on that, and it was a very good way of ventilating the technical issue that arose between the parties. I've got another one at the moment which is being mooted. I'm opposed to it, for example, because one of the questions is when did the business commence, and since that is a question of fact, it seemed to me that whoever negotiated the agreement, someone was going to lose. So some care does need to be paid to what you're going to look at and how you're going to agree it.
Just on that question again of agreed statements of fact, my own experience is that it's very important to consider the wording when you are the recipient of a proposed agreed statement of facts. And there's a little detail in the wording which doesn't seem to be quite the way you see it, but you're not entirely sure that it goes directly against your case. Well, I would warn you to scrutinise it very, very carefully in that event, because usually with skilled counsel on the opposing side, the wording has been chosen very, very carefully and will often have been chosen to just nudge the case a little bit towards their side of the spectrum. So again, I would caution great scrutiny before you are letting an agreed statement of facts go in to be filed.
Is it possible to agree to an extent? So, right, we agree on these issues, but disagree on these issues?
Yes. The answer is yes, although one of the uses of an appeal statement is to enable that to occur in a quasi-pleading context. So if a bunch of facts are pleaded out properly and the Commissioner admits them, then they're not in issue.
And in the event that you did want to bring an expert witness to Tottenham, are you at the scheduling conference, would they need to appear to discuss what they're going to do?
No. You'd be required to explain that you will have an expert. You may not have identified who they are, to give evidence about X topic, quantum or whatever.
And you may, for example, be in a situation where you are unable to properly brief an expert until such time as discovery has occurred. There may just be too many factual gaps there. But on the other hand, we've probably had cases where experts are retained at a very early stage. And it's important, of course, that an expert is not an advocate for either side. The expert is there to assist the court with the matter of opinion. So it might be a question of foreign law, or it might be a question of valuation. I once did a case which involved, I think there were 3 expert valuers on the other side and 1 valuer for the Commissioner. And one of those experts was quite, struck me in any event as being quite an advocate, and he was just ignored in the trial judge's conclusions. So that's important for setting the approach of the experts as well. And yes, so experts do have a role to play. Some judges, I suspect, certainly the other area which I deal with is competition law. Some judges would almost prefer experts not to appear, I think, would be fair to say. But with the hot tubbing of the expert, that will never occur at a scheduling conference. It will occur usually at the trial, although the court may require the experts to confer in advance of the trial to try and thrash out some of the issues. But at the trial itself, ordinarily the experts will make a statement of their position, their opinion. They will then sometimes have a discussion amongst themselves, which can appear to be more like a cross-examination of one expert against another. And then there will be questions from the bench sometimes as well, and then there will be a cross-examination proper by the opposing counsel of each expert, unless there is agreement on the part. So one of the issues is how the expert is going to actually appear in the courtroom. You can be a top-notch expert in the sense of having a comprehensive knowledge of your area, and that makes it very difficult for counsel to cross-examine them. But you can present very, very badly indeed, which some experts will make too many concessions. Sometimes those concessions will be properly grounded, but some experts are a little bit like straws in the wind, and they will just go whichever way the wind is blowing, and they will agree with this and agree with that, which is not terribly helpful, and it confuses the judge as well. And perhaps that's what will lead to the judge finding the expert evidence is not of assistance and ignoring it completely. But no, so the expert's presentation is important. So there are two areas there, and of course for counsel, the most fertile ground for cross-examination is usually the expert's assumptions. So they need to be based upon the facts, the evidence. If they're not, then they leave themselves open to be impugned, and the basis of the expert report undermined.
I just say, just because an expert or any other witness is there to help the court doesn't mean they can't be prepared. You can spend a lot of time with an expert quite properly within the bounds, testing their evidence, testing their assumptions. I had a commercial case that was in front of Justice Gordon where she decided at the last minute to hot tub the experts. It was just a commercial dispute. My expert said the shares were worth 16 million, their expert said the shares were worth nothing. We were a long way apart. She put them in a hot tub. The experts came away agreeing that the shares were worth $500,000, and that's what Her Honour ordered the damages for my client. You do need to be careful and push and win. He was prepped to death, but the other expert was obviously more persuasive than my guy, and he rolled over when they went away to see what they agreed and disagreed about. You don't just ask them the questions and see what happens. The process can be more robust than that, bearing in mind the expert's role in particular.
I must admit I'd have more to say on this subject in a fortnight's time, because I'm about to head into a trial up in Sydney where we've got a hot tub that's going to include 4 valuation experts and 1 geologist. But I will say the process that had been ordered for our experts in that particular case also involved a conclave where obviously none of the lawyers were involved, and we had a retired judge who was being the person who was actually coordinating all the experts and dealing with them. And from some of his updates, I got the impression it might have been a little bit like herding cats, because our experts actually ended up further apart than they began, with 14 areas of disagreement at the end of their joint report process. But what's been ordered for my case next week is that all of them are going to be sworn in together. They're going to be given sort of 5 minutes to present on each of those 14 subjects, although mercy, we're actually going to sort of narrow it down to 7 that we think are important. And then there'll be an opportunity to cross-examine each of the witnesses, depending on whose expert it is in particular. And obviously the judge will also be asking some questions as well. So I'll be interested to see exactly how that goes, because they are a very, very long way apart. and obviously a little bit more intransient than Michael's expert turned out to be. But as I understand it, the process differs depending on who the judge hearing the particular case is, so it can be different every time.
Comment on all the question.
No, I think I endorse what Ian said, and basically the more thorough the appeal statement, the more persuasive it is, I think, so that's the aim. That's what the judge will look at when preparing for the hearing. So the more thoroughly the case is prepared and right from the start with the appeal statement, the better for the party involved.
Can I just end with a plea on that for those Commissioners' representatives? You can leave out the paragraph that says you rely on the onus of proof and reserve your rights under 14 ZZK. It doesn't help.
All right, well, if there are no other questions related to that topic, it might be useful to move to another question that was touched on by Stephen, that is how frequently there's an occasion in this area for the ordering of split trials, and whether what approach should be taken to that question and how frequently it should be resorted to.
I've had a bit of experience with split trials, principally opposing them, and largely for some of the reasons that have been averted to, because they don't necessarily add to any great efficiency, or when it turns out that you're actually considering the question that has been proposed for the split trial, it doesn't necessarily avoid some of the complexities in the supposedly parked issues. That said, I am aware of one tax matter where quantification was hived off, and I think that was just a manageability factor, and it ended up being an agreed split question. And I think principally the reason for that was because the parties within the time available just couldn't have coped with some of the quantification evidence that was involved. I don't have any in principle disagreement with them, but I think that you do need to be very, very careful in terms of how the questions are framed and exactly what evidence goes towards addressing each of the questions, and in particular the question that you're dealing with first.
I've never had a split trial in tax case, so I'm probably not qualified to comment. In commercial cases, it's almost always ended in tears, so I just caution.
Yes, I would agree with Michael. I'm certainly of the view that split trials, the advantages or perceived advantages in terms of reducing the amount of court time and expediting the time at which time required for a matter to reach resolution are often illusory. I've had several experiences of split trials, and with hindsight, each of them would have been a whole lot easier, would have been resolved a lot more quickly, a lot less expensively for the parties, and would have required a lot less court time had all the issues, so the remedial issues, the penalty type issues, being dealt with at the same time as the substantive issues. In tax cases, when I think back over the tax cases that I've been involved in which have involved penalties, well, generally speaking, the penalty issue, although it might be perceived as a separate, discrete issue, it's usually quite a confined and narrow issue. There are cases where the penalty itself is a very substantive issue, and there might be more justification for splitting the trial then, but in some cases I've been involved in, the Leighton one was an example. The issue of penalties, I think it took about 5 minutes of court time, and very little involvement of either party. Basically almost seemed to follow the event. But look, each case is different, so and then that's the important thing with tax litigation. It's important to not think that you have been down the road before and hence this case will be the same as the previous cases you've been involved with. So what is important, and this is where there's a skill required of a good lawyer to really sit down and think about the case, think about what are going to be the issues, because has been my experience that parties will only sometimes think about the case in the weeks leading up to the trial, and that's when they will suddenly realise that there is a glaring omission in their preparation, a glaring omission in the evidence, or there is some legal point which they have not really given the required or requisite amount of time to considering. So yes, I one case in the Supreme Court which involved a split trial. I think that went on for about 10 years essentially. So, and I'm aware of other cases where the lawyers have been sued because they have mistakenly assumed that a matter was a substantive legal matter, and the trial judge has handed down the decision on the substantive legal matter, and when it comes down to the separate trial for the relief, the remedies, suddenly it's appreciated that there is a gap. And you might like to think that all parties will be prepared to allow the substantive issues to be reopened, but it doesn't necessarily happen that way. So again, you need to give a lot of thought to what is in fact a substantive issue and what is a question of relief, and it's the same with tax cases. Is the penalty truly a discrete area, and have you covered all the evidence, etc.?
If I could just make a short observation from a judge's perspective, I think there's a temptation, because of the use of the expression split trial, to look at it in the wrong way. The concept of a split trial comes from common law and commercial trials, where the traditional split is between liability and the assessment of damages. I think a much more profitable way to approach the question, certainly in a tax context, is to ask whether there are any preliminary or separate questions that should be tried, rather than talking about splitting the whole trial. And if you think about it in terms of a preliminary or separate question, there quite often are questions such as whether the taxpayer owed a debt, or whether the taxpayer was in fact the owner of certain shares, things like that, which arise as a discrete issue before questions like valuation come into play. And the way that question is answered might render it totally unnecessary to embark on an examination of valuation evidence, which, as we've heard, can be quite intensely disparate. So I'd say that I generally agree with the cautions against split trials in the traditional way, but I think it's useful to keep an open mind and to canvass at the scheduling conference whether there is some issue which can usefully be hived off and resolved with a possible saving in time and money.
Yes, I would say that you need to carefully consider the consequences of the result of the specific issue being preliminary in a preliminary trial, so that I guess both parties are agreed that the consequences of particular results on a specific issue. So if the parties have a different idea about which way, what a particular result will mean, there might not be any saving at all in time. So the possible consequences of the trial of the specific issue need to be considered carefully. And if everyone agrees that there will be a saving of time, then one would think that would be the best result.
Yes, I don't say that separate trials of separate questions or issues are always advisable, even where the separate issue might potentially be definitive of the or determinative of the whole case. One illustration where it's undesirable is where questions of credit of witnesses who will also be called on the remaining issues arise, because if the judge determines that question one way, in a way which reflects adversely on a particular witness's credit, and the other issue comes to be litigated, that judge is potentially almost disqualified from adjudicating on the rest of the trial. Questions? Yes.
More of a comment part of two split trials. First one I suspect is one Melanie was alluding to, is petroleum resource rent tax case, where it was manifestly sensible to have split trial in the sense of 13 questions to be answered to determine the points on the production platform where streams of hydrocarbons were to be taxed, because there were 96 combinations being put forward by the taxpayer, and depending on which one of those 96 were found to be correct, the valuation would then have to follow, and there was something like more than 4,000 different permutations of valuation. So to have it, not only would it take months, but it would be wasteful to have people doing 3,999 valuations when only one turns out to be relevant. And in that case, we did do it by very carefully crafted 13 questions that senior counsel put a lot of work into getting agreement with the judge. And in that case, it did save time because, as it turned out, it was determinative of the proceedings. The second case where I had it split was where the judge said it was a Section 44 appeal, and there were substantive questions of law and there were penalty questions of law. And the judge of her own motion decided that she would hive off the penalty questions of law. We could probably have dealt with them at the trial, but that was her preference, and I wasn't going to argue against her preference. In that context, one circumstance where you may be very sensible to hive off a separate penalty question is where there's a serious attack on the Commissioner's remission decision on penalties or JIC, because that's unlike most Part 4C litigation where the Commissioner's processes are irrelevant. A judicial review type attack on the remission discretion, which usually involves going through the processes and the information before the decision maker, is quite a discrete area, and it's wasteful in some senses to engage in that examination of the Commissioner's processes if, as a result of the substantive tax, you never need to consider remission of penalties. So those are the circumstances, but otherwise I agree. Often it's the advantages of split trial are illusory.
Yeah. So just picking up on the remission issue, particularly remission of JIC, there was a sort of trend there for a while for everyone to put in their judicial review ADJR for those things, and then have the court basically have an order of dismissal that wasn't entered, so it just sat behind. So it wasn't quite a separate question issue, but it was sitting out there extant to be dealt with, reinstated and dealt with in the event that it became necessary. I have been involved in some situations where there's been a very serious discussion about whether to split penalties, because from a taxpayer's perspective, in order to contest the lack of reasonable care finding, consideration was being given whether to waive privilege over advice, and that wasn't something that they wanted to do while the substantive issues were on foot, or certainly wasn't something that they wanted to do if it turned out to be unnecessary. So there occasionally are some strategic considerations there. But certainly I've been involved in opposing separate questions where the separate question was framed in such a way that if you actually thought about it, wouldn't dispose of the trial in its entirety, even if it was decided in favour of one party or the other. So I think it is necessary to frame the questions very carefully and think very seriously about whether or not it's a step that you want to take.
Just on that point as well. Of course, we are approaching the question of split trials on the basis of our experience and to some extent with hindsight. Thinking about some cases I've been involved with hindsight would have been very easy to split the trial, but it doesn't appear that way. Now, one example, the ESSO Petroleum Resource Rent Tax case, which Vincent Tavallaro, sitting over there, was involved with, and ESSO was denied special leave back in August of this year in that matter. But essentially, there was lots of evidence filed on behalf of ESSO, most of which I would say with respect seemed to be relevant. But the question boiled down to whether a service agreement entered into between ESSO and its subsidiary for the provision of services for ESSO's entire operations in Australia and the continental shelf could be apportioned. So the fees payable under that service agreement could be apportioned so that the apportioned amount could comply with the deductibility provisions under the Petroleum Resource Rent Tax Assessment Act, which required that the deductions be limited to amounts incurred in respect of a project. Now, the project in question was ESSO's Bass Strait project, the Gippsland Basin joint venture. Now, I think Don was in fact the trial judge in that matter. And then there was a lot of evidence presented, although there was no cross-examination as it turned out. But in the full court, the full court started off by asking whether the section permits an apportionment. Now, to some extent, I think the Commissioner had assumed that an apportionment was permitted under the Petroleum Resource Rent Tax Assessment Act. But the full court found that, well, no, sorry, the provisions don't permit an apportionment at all. There were other grounds, of course, but essentially the decision is explicable on that basis to a large degree. So that a lot of the evidence with hindsight could have been deemed unnecessary, but all parties, I think, thought the evidence was relevant at the time. So again, it's not a perfect world, and lawyers and counsels and even judges' perceptions of a case develop over time. So that's just something to bear in mind.
Are there any other questions arising either from the last issue we've discussed or from something later in what Stephen has said, or generally? Do we have any further questions? Very well. Well, I think it's almost 9:15. I think the fact that we've concentrated so heavily on really only two discrete areas over which Stephen has ranged this morning shows just how much scope there is for discussion of a topic like this when you have a group of panellists such as we have this morning, who can bring such a range of direct, hands-on experience to the discussion. And I think it's all been very illuminating, and will allow each of us to go away from this seminar with some new ideas about how to approach particularly the formulation of appeal statements and what should be ventilated at scheduling conferences. So I'd ask you to thank our panellists in the usual way.